Good morning, good afternoon, and good evening, wherever you happen to be in the world. Thank you for joining us. This is the Brilliance in Commerce House of Freedom International Law Trust Zoom meeting for September 17th, 2025. This September is an amazing month as the 9-9 portal. This month represents the apex of closing out transformational cycles, ushering us towards the new year, which will begin the new cycles accelerating humanity towards a world of greater freedom, sovereignty, and abundance for all. This month contained the blood moon eclipse on the 7th and the apex of the portal on the 9th, giving us the 999 code for master completion. The solar eclipse is coming on the 21st, followed by the autumnal equinox on the 22nd. This is the time we must let go of all that is old in order to make room for all the new that is to come. All is happening in divine timing. Brilliance in Commerce is a project of La Verite, which means the truth in French, and we have a few different programs, as you may be aware of, on the website. We are members of the Worldwide Charter for Fair International Commerce. You may enjoy reading through that on our website if you haven't already. More information is available at house-of-freedom-trust.com. For those of you who need our phone number, it is 360-200-7521. Again, that's 360-200-7521. Tonson Fairmont is the most humble founder of Brilliance in Commerce. He has a background in Bake Instruments investing and is also the author of Sovereignty Consciousness, a great read if you haven't already checked it out. Randall Hillner was the creator of the Natural Law Trust that we use here at Brilliance in Commerce after years of studying under his mentors. He is now retired, and Bradley Long is carrying on the torch after having mentored with Randall Hillner. He now writes our trusts and is doing a fantastic job serving our clients with a dedication to humanitarian projects and his long-standing support of the sovereign revolution in helping people escape the matrix. Will Barney is a former banker and experienced speaker who works hard to give us the good news and also helps out in these webinars with answering your trust-related questions. He also works with us to provide monthly presentations of all the good news happening in the world. Our next World Situation Update webinar with Will Barney is next Thursday, September 25th. I'm your co-host, Seth Harris, architect of holographic socioeconomic systems that support and enhance equality, freedom, sovereignty, and abundance for all. And I am beyond grateful to be serving as the editor for Brilliance in Commerce and the host of these webinars. Joining us today is Jude Cisneros. Jude positions himself to empower people through law to pursue their passion and their ministry as a profitable livelihood by leveraging strategic business and estate planning using non-statutory common law pure trusts, which are very similar to the NLT we offer at Brilliance in Commerce. Unincorporated associations operating inside those trusts, and tax-exempt nonprofit organizations, particularly the 501c3 church with 508c1a mandatory exemption from all IRS reporting to help clients focus on their calling. The views expressed by Jude today are his and his alone and are not to be attributed to any organizations with which he is affiliated. After Jude is finished speaking, we will open up this webinar to questions. Please feel free to write your questions into the chat or raise your hand if you would like to be unmuted to speak. If you are calling into this webinar through the phone, you simply need to press *9 to raise your hand. Please keep in mind that if you raise your hand after you speak, you will be muted again. And if you have more questions, feel free to raise your hand again and I will call on you again. Okay, Jude, thank you for being here. It's a pleasure to have you. I'm sure we all look forward to hearing what you have to say today.
Well, thanks so much for having me. I've watched a few of these, and I'm ready to follow your lead if you have some guidance as to where we want to go first.
Just go ahead and tell us the highlights of your career. I'd love our audience to hear about all the work you've been doing.
Well, I appreciate that, Tonson. I'm a man of humble beginnings, born and raised in Albuquerque, New Mexico, to immigrant parents who emigrated to this country long ago. And I am a freedom fighter. I've been practicing law for 28 years, mostly as a litigator. But I've been in the bowels of what I like to call commercial Babylon and the legal law firms, Fortune 1 at one time. So I've been in-house counsel with corporations as well as today I practice. I still do some litigation. I do a lot of estate planning, as Seth mentioned, business and estate planning, and I represent some clients in active court litigation involving tax issues, although I tend to ghostwrite for those clients because, as we all know, many of us in this space like to educate ourselves, inform ourselves, and stand on our feet to take on the system. So I act as a support for clients in some of those situations, both with regard to federal taxation and state taxation issues. I also act as independent general counsel for clients that run enterprise business throughout the country, throughout the world. And I do so with particularly the use, it's a proprietary blend of the common law trust that we've talked about, like the natural law trust, or what I call the pure contract trust, operating unincorporated associations, which are not tethered to the state. I encourage my clients to pull out of the system as much as possible. In some instances, it's not always possible, depending on how much front facing to the public my clients' organizations may have. But ordinarily, the objective is to try and untether LLCs and corporations, C corps, S corps, partnerships, et cetera, and form unincorporated associations, again, operating inside the trust. So it has a level of protection for to limit liability. And then otherwise, like Seth mentioned, I do form the 501c3 church with the 508c1a mandatory exception status from reporting requirements to the IRS. And then finally, as part of my proprietary blend, I use franchise agreements, private contracts under Article 1, Section 10 of the Constitution, the all-powerful contracts clause. Contract is king. And once we've created a sort of matrix at the micro level for the families that are my clients, then they're able to operate their systems, including franchise agreements, to leverage against otherwise taxable capital gains or other types of taxes for those sorts of holdings that your trust might have that include that will garner 1099 1099 or K1, 1098, other types of income. So again, the franchise operations help to drive those drive deductible losses for the organization up, and thereby eliminate or substantially reduce taxes.
Well,
Awesome.
thank you for being a champion of the rights. You have any stories of cases that you've won?
Geez, there's in the space that we are in, yes, I've won litigated matters in straight commercial contract disputes and different things like that. I've done a lot of different types of commercial litigation, but in this space, it's a very uncharted course, as we all have had that experience. So by the time a client comes to me and is in some kind of hot water with the IRS or has been, sort of railroaded in the courts of law, it's a constant moving target for us, because the courts of law, if you will, don't necessarily understand the law of the free man, or the common law for that matter. Everything is statutorily driven, which is, I know, a big focus of Brilliance in commerce, for example, with the NLT trust, is to ensure that it is a non-statutory, as the Supreme Court has referred to the common law trust or the pure contract trust or the natural law trust. These are non-statutory because they receive no benefit from the state. Therefore, there is no reporting to the state. But because that's the case, the courts do not understand how to handle the likes of the arguments that we have to advance to support. I'm not talking about trust at this point. I'm more talking about the free man or free woman caught in the crosshairs of Internal Revenue Code or other such statutory constructs. So winning is it's a day-to-day sort of development for each case, for each client. And it doesn't always look like what other commercial litigated cases look like. So, for example, we often have to get out of a state court in order to get to a federal court to begin to move the needle, if you will, with regard to the types of arguments that we have to advance. And some of my clients have been in the crosshairs of the IRS for 25 years. Other clients have been stopped and detained on the roadside, and we're advancing writs of mandamus on their behalf, getting some traction. But again, there's not a real way to quantify what success is in this space other than just continually moving forward. And I'm sure that over time we will have, I'm hoping, have significant victories to talk about. And there are several cases right now that are in the works that could make enormous differences for this entire movement. But as they say, the wheels of justice turn slowly, so it's going to take some time. Good question, though, Thompson. Thank you.
And most of our natural law trustees understand that they cannot really get much good out of certified public accountants because they're brainwashed in the system. But
Absolutely.
you have bookkeeping service, which may I ask, is it are these bookkeepers who are not certified, which would be to our advantage? We don't really like certification because that means they're loyal to the statutory system.
It's a great question, Thompson. And the answer is yes. I'm a small organization. My operation includes about 3 or 4 of us, frankly, that are doing the work. I carry the load with regard to the to litigation and legal, or I should say, business and estate planning. But the bookkeeper, who is my CFO, is in fact not a CPA. And I do agree with you that the CPA title brings with it a load of requirements. And I haven't found a lot of CPAs that are really awake to how to stick with the dynamic nature of the business and estate planning that we're doing. Particularly, most folks in that space are very, they're afraid of the IRS. They don't, so they'll tend to even take some of my clients and say, for example, I have created organizations that are fully intended to be off the radar, not tethered to the state. They're not incorporated entities. They're unincorporated associations for a reason. They're recognized under Code of Federal Regulation as business entities, so you can't discriminate against them if you're the banks or people doing transactions with my clients. However, if you have a bad CPA, and what I mean by that is somebody that's just tethered to the system, they can't break the mold. And I understand it. I'm a licensed practicing lawyer, and I have a license not because I believe in licensure, but I believe it's the only way right now that I know of to be able to represent some of these clients that are caught between a rock and a hard place. So I maintain that license for that purpose, but it is hard to find other lawyers that are awake to the principles that we're talking about and that are confident in having their clients challenge the system, the status quo. Same thing for CPAs. They're going to tend to drag, in some instances, they'll take an unincorporated association and try and drag it into a reporting relationship with the IRS. So yes, it's very important to have somebody that's awake. My bookkeeper, Diane Bradshaw, runs Bradshaw Bookkeeping and Administrative Services because the bookkeeping that she does, in some instances, yes, my clients need to have something reported to the IRS, either because they garnered 1099 income or some other reportable income by a third party. We have to do something about that when it comes to your trust operations or your unincorporated associations, et cetera. So Diane of Bradshaw Bookkeeping is very much awake, astute to the ways that we have organized things, including the natural law trust. And so she knows how to not just maintain books for tax keeping purposes, but more importantly, for those of us that have no tax records, how do you prove to the world that you have sustainable income, profit and loss, balancing the books, good business acumen, that you're managing your affairs properly, sophisticatedly as a dutiful business person? So she's fully aware of and integrated into my process so that we can provide those types of services exactly.
For any natural law trustees who might be interested, what approximately are Diane's hourly fees?
Her hourly fee, pardon me, her hourly fee is $250 an hour,
Hmm.
and I'm not sure if she veers from that, but that I know that's her standard rate.
Thank you.
She's very good at the books, by the way. This woman loves numbers, and God bless her for it because I can't stand the business world she's in. But I know that our mutual clients need somebody in that space. So I'm really glad to offer up her services for anybody that has that need.
I've got a question, Jude. So, big concern for people when if they're still in need of raising finance, either for a mortgage or business loan or whatever. Obviously, if you're no longer filing taxes or you know, dropped off the radar, so to speak, by having a natural law trust, what's the best way to facilitate that for them by working with Diane in terms of getting yourself on the radar, albeit temporarily, just to be able to go to the bank and say, right, I need a mortgage and here's my proof of income. How does that typically work?
Yeah, it's a great question, Bradley. Thank you. I can't speak for Diane, but I know that she gets every client from the very extremely organized to those that just have paper, the equivalent of bankers' boxes of e-paper
Yeah,
that they just sort of push out to her, and then she's got to cull through all of that. So her experience with each and every one is different, but she's extremely good with paper, with documenting your process, and typically can go back several years, most importantly, to bring forward losses that can be reported against so-called taxable earnings.
yeah,
But yeah, so she's going to be once you develop a system with her where either you're keeping your own books under her direction and then providing her the data that she needs, or you're providing her the whole kit and caboodle, the banker's box of documents, and letting her organize it. Obviously, that's going to be more expensive, but regardless, what she's able to do with that documentation is put it into spreadsheet formats of various descriptions. I mentioned profit and loss,
yeah,
chart of accounts demonstrating the integration of multiple entities, um, uh, balancing the balancing of the books. Yeah, so I'm not really sure of all the different types of data that she can put out for a particular client, but typically a client will, as you described, Bradley, not have a sort of taxable record because they've stopped playing the game for a long time. So then how do they show profitability? It's and with most applications, whether for transacting any of a number of businesses or business transactions, the request is typically, well, provide X number of years of your tax records. And
yeah,
for some clients, that just, that's kind of like, okay, that's a closed door. It doesn't have to be a closed door because the fine print, and think about it, there are people and entities in the world that are tax exempt. So the
yeah,
banks can't discriminate on the basis of whether you file taxes or not. Because if you don't and you're tax exempt, then you have to have an alternative methodology for that client or that prospect to provide some indicia of your profitability, your business acumen, your business management, et cetera. And
mhm,
that's the kind of documentation that once Diane establishes a protocol with you, she can spit that out in a matter of an hour. Just depends on what the specific client need is.
amazing. So potentially there's a solution there where, let's say they're running everything through their trust and they now need to go and acquire a property via a mortgage. And obviously raising finance against the trust is tricky because lenders are nervous of the irrevocability and being able to recover assets if you default.
Right?
But you need to prove the profit and loss of it if you do happen to find a lender that will work with you, or if you need to start putting yourself back on the radar in terms of pulling money from the trust, as income to be able to prove income for lendability. Is that a scenario she typically works with?
Any of a number of things can happen in the situation you just described.
Yeah.
For example, if you have a bank or a financial institution that's nervous about just dealing with the trust, maybe it doesn't have a lot of history,
Mhm.
a credit record, if you will. They
Yeah.
could ask for the trustee can sign off on, or somebody can sign off on a promissory note, or not a promissory note, but a personal
Guarantee.
guarantee, if you will.
Yeah.
And now I know we all want to avoid sort of drawing liability to ourselves. But
Mm.
once you know that your operation through the trust is viable, it's capitalized, it's got a long life ahead of it, it makes it very easy to sign off on a personal guarantee without having to go through all the motions of pulling assets out of your trust, which could be tricky,
Yeah.
uh, because they're in there for a reason. They enjoy limited liability. We're protected from creditors and other ne'er-do-wells, if you will. So
Yeah.
it's not always ideal to pull those assets out and put them, for example, into the name of an SSN.
Mm. That makes sense.
Now, one thing I want to point out, Bradley, because your question sort of touches upon it, and that is that for those of us that are tax-free because we have emancipated from the tax system through either a revocation of election, or I have a process that is totally legal based. It's a legal brief, if you will, in which I tell the IRS for
Mm.
myself and on behalf of clients, we're not doing the what do you call it, the income tax game with you guys anymore. Anytime we've made those sorts of submissions in the past, we renounce those. We made those under mistaken impression of law. But now that
Yeah.
we understand how the system works, we're no longer going to be a part of that system. So count us out and change our status to non-taxpayer.
Yeah.
Um, we get great results with that. There's no affidavit process or disclosure of, frankly, many details having to do with the individual.
Mhm.
And we find a lot of comfort in that. Nevertheless, we don't want to make that social security number a potential target for audit, investigation. And if you start moving large assets out of a trust, there's the potential that somebody in the future could cry foul play, and that this
Yeah.
was somehow a diversionary tactic to avoid liability. So
Yeah.
it is possible to have the trust speak for itself with some backing by the trustees or somebody else that's going to back the loan, if you will.
Yeah. Okay, cool. Good clarification.
One other wrinkle, and that is that when we are tax-free in our Social Security number, we're exempt from taxation. We've done the revocation of election or my process. That makes us free only in the Social Security number as individual men and women.
Yeah.
That's not the same necessarily for any trust, including the NLT trust, the pure contract trust, the common law trust that is non-statutory. If it yields or if it garners 1099 income, that's a third party reporting that you somehow may be an employee of the government and that this asset, this trust asset, may have a reporting obligation. So in those circumstances, K1 income, 1099 income, whether you're talking about a trust, an unincorporated association, or anything like those entities, we have to have a protocol. We have to have given some thought to what are we going to do if the IRS or the state revenue offices come asking for capital gains on a certain transaction that was disclosed by a third party having nothing to do otherwise with your organization.
Yeah.
Well, our
So like,
experience has been, Jude, I've been using these since 1993. My predecessor, Randall, was using them since the 1970s and 80s. Since then, we've had thousands of clients. Not a single one of us ever have had any problem with the tax man.
Absolutely.
Maybe
And
once or twice there's been an inquiry, and we simply respond that we don't use the word exempt, we use the word it's an exception, and they
yeah,
go away. We've never had any problem.
yeah. Well, with the NLT in particular, consider that I've got clients in all ranges of the spectrum. So some are, I'd say more sophisticated in what you just described, Tonson, which is, hey, we don't have a reporting obligation here. And, simply in some instances, instances not responding at all or not reporting, whatever the case may be. I've got other clients, however, that are running big industry, large operations, and they don't want to get too close. They will come up with all the sort of narrative descriptions of people in the past that have it's been handed to them by the IRS. They've gone after them. They've made a public example, if you will, of them. So I've got all ranges of clients, and sometimes it's not enough for them to just hear, well, you don't have a reporting responsibility. But the fact of the matter is, with the NLT trust or any pure contract or common law trust, so long as that asset is parked inside the trust and it's generating revenue and all these other things, if it's not making a distribution, there's no taxable footprint. So, a very important principle. We got to live out of the trust itself.
Well said.
What we usually do on these trust webinars is turn it over to the audience for questions and answers. And so, Seth, I'd like to suggest that we allow everyone to know that questions can come to Jude as well as to Bradley and Will and myself.
Well, with that, we already have one question in the chat. And as for everyone else, if you have any questions, please also put them in the chat or feel free to raise your hand. Again, if you have called in on the phone, you just have to press *9 to raise your hand. So the first question that we have right now is from Chris. Might not a certified bookkeeper's product afford some added credibility on behalf of a trust with potential lenders? There are two major credentialing bodies for bookkeepers in the U.S., American Institute of Professional Bookkeepers and the National Association of Bookkeepers. So again, the question was, might not a certified bookkeeper's product afford some added credibility on behalf of a trust with potential lenders?
Is that a question for me?
I
Guess so.
believe so.
Okay. Yeah, credentialing can be important, especially when you have public. I say public. I think we all understand what I'm trying to say. When we have organizations that face out toward the world and do business and transactions in the world, yeah, credentialing it can be pretty important. I find, however, I'm not sure what Diane's credentialing is. She can talk to you guys about that specifically. But she is the daughter of her father, long since passed, practiced for 40 years as a full-blown CPA, employed her as a young gal many years ago, and she's now got a long time, a long track record, 30, 40 years herself as a bookkeeper without being a CPA. But she knows all the nooks and crannies of the Internal Revenue Code. And they constantly change, by the way. I mean, she's been working on client matters with the September 15 deadline for entities just in the last several days and found new wrinkles because the IRS is constantly at their shenanigans of changing, moving the goalposts back or adding some new level of guidance or other schedules to be kept. In any event, with regard to taxable issues like that, I think that the bookkeeper role is relatively safe from excessive scrutiny. I would say where we find more friction is where you have a class of investors that wants to be part of your organization or wants to do business with your organization. That's when they get a little bit nervous about the structure and the formation of unincorporated associations. So in some instances, we'll have an LLC or a C Corp, S Corp type of organization as a front-facing operation. And I find that that is a little bit more where we find the sort of resistance or the idea that we need a little bit more bells and whistles, a little bit more credibility as to the formation of these organizations. People feel real comfortable out in the world that do business with us from time to time when they can go to the Secretary of State website and find that you're in good standing. So, yes, I think the bookkeeper role is important. Credentialing can be important, but I don't think it's as significant as the overall enterprise and how your business and estate plan are formed.
Thank you, Jude. That's a great answer. And Chris, I might add that if you're talking about presenting the natural law trust to lenders, I might suggest, and Jude might agree, that you get an LLC or some statutory entity to do that and not try to make the trust itself a borrower, but let you in the individual name or in a statutory name do the borrowing and presenting the certified credentialing and all of that for lenders. Let the natural law trust stay in the background as the tax exception entity that doesn't have any credentialing or any association with certified bookkeepers.
Yeah, Thompson, that's a great point, and it is one of the reasons that I use the unincorporated association. Guys, remember our natural law trusts, our pure contract trusts, our common law trusts, and they're all the same. What I'm describing is a non-statutory trust. They're all intended to bring us into the private, but the more that that natural law trust does business or in interfaces with lenders and institutions and customers, you're bringing it closer and closer to a liability situation. So we do
Yes,
want to sort of create a layer of insulation. I
right.
do that through formation of the unincorporated association, which is owned 100% by the trust itself. Now the trust is protecting the operation of that unincorporated association, or as Thompson suggested, maybe you even need an LLC if the folks that are part of your organization want the bells and whistles of an organization that's on the radar. Sometimes you need to do that. But by operating it all inside of trust, and I don't mean the trustees operating the business, I mean the trustees acting as a president and vice president over the operations of the unincorporated association or the LLC, et cetera. But that is a good way to keep your trust from being sort of tainted by too much familiarity with the outside world. Again, these natural law trusts are intended to be our private institutions to protect our family legacies. So we don't want too much uh, mixing with other institutions and organizations.
Right. And the trust can own a majority of the assets of the LLC and thus minimize the taxes that the LLC owes.
Absolutely. Add one more wrinkle on top of that, Thompson, and here is why I do the 501c3 church with the 508c1a designation that we don't report a single thing to the IRS. Because once you do that, you can the formation of the church and its existence under its own ecclesiastical self-governance model, which is a Supreme Court. I mean, it's the doctrine of the Supreme Court. It's called the doctrine of autonomy of the church from the state. It's also referred to as separation of church and state. It's backed by freedom of religion and all the other constitutional provisions that protect assemblies. But what the church does by its mere existence, if you create a relationship directly with your unincorporated associations, now those organizations are conferred upon them by the church 501c3 tax exempt status as well. And that's under 508c1a law, which specifically says the church, its integrated auxiliaries, conventions, and associations of churches are completely exempted, both from seeking recognition with the IRS for tax exempt status, which by the way, the IRS does not determine tax exemption. That's not their job. And that's not what the rules say. The world thinks that that's the way it operates, but it's not the case. The determination of whether you're a proper 508c1a church is how you're formed. It's a matter of law, not a question for the IRS to determine or not. All the IRS can do is determine whether they will recognize your status or not. But we don't need to ask permission to be recognized. And that's the mistake that many make when they form a church or these organizations is they go and seek recognition through what's called an IRS Form 1023 application. We don't need to do that. And also under 26 USC Internal Revenue Code 6033, you're mandatorily accepted from filing annual income tax returns. And that's the law that applies both to the churches and its integrated auxiliaries, which I like to call ministries.
All right,
Interesting.
perfect. Thank you. Oh, go ahead.
Yeah. I was just going to say, so do you layer those religious organizations on as standard, or is it only when someone needs to interface more in the public realm?
Part of what I'm doing is, as I mentioned earlier, I refer to the system as commercial Babylon because commerce really got invented, in my opinion, in Babylon with the minting of coins in circa three or 2500 BC, something like that.
Yeah.
If time is a true construct. Okay, let's start with that. But operating on this plane as we do, um, it's this commercial Babylonian system is, how do you untether from it and keep yourself viable? Because without having a social security number in a bank account or an EIN number in a bank account, what are we going to do? Like we all have to have options. So they've left us no reasonable alternative but to do business using their coinage or the almighty dollar. And we know that that's in flux right now. There's a lot of changes going on there. But I'm developing a system of operations where I'm linking these churches with the clients that are coming to me from all over the country. And we've formed approximately 15 churches to date. And these churches are all integrated through my methodology, which is called the self-governance protocol. It's part of what my offerings are at Center for the Protection of Inherent Rights. And what that does is we do a couple of things in one fell swoop. Well, three things actually. Number one, by forming the church, you've created a 508 construct that doesn't report to the IRS.
Mhm.
By so doing, that client can now form unincorporated associations that are also tax exempt pursuant to 508c1a. And thirdly, now that they're linked through Center for the Protection of Inherent Rights and the Self-Governance Protocol, and my particular church, which is called Lighting the Way Home Fellowship, that church organization also has a convention of churches. It's called Lighting the Way Home Fellowship Convention of Private Assemblies, another 508c1a. So remember, 508c1a says the only institutions that are protected from taxation and not having to report a smidgen of information to the IRS is the church, the integrated auxiliaries, and conventions and associations of churches. So I've got three layers out of the four. Well, it's really the four layers because conventions and associations are the same thing. But now that we have a link of these churches, we've added an additional layer of protection because we're demonstrating to the IRS and to the others in the other alphabet soup agencies that there is viable economic validity to what these organizations are doing. We're all networked as part of this construct. So that's a unique offering that I'm making to my clients to try and actually do. I got tired of just sitting on the sidelines and waiting and watching. A lot of information out there about being tax-free, but how do you actually do it? Now, how do you run enterprise in the world and stay tax-free? This is the methodology that I've devised, and that's the offering that I'm making. But to answer your question, sorry, it's so long-winded, Bradley. No, not everybody does the church. Some people just want to run straight business ops, and that's great. We can do that for you using your trust and your unincorporated associations and mingling in the franchise system operations internally to your construct. Then we can totally drive down taxability, et cetera. And it's all legal, lawful, legitimate. It's what corporations do in corporate America.
Yeah. So it's kind of like modular in that sense. Is that how you
It is
describe it?
modular. Yeah, absolutely. And I actually have a diagram where it sort of
Yeah.
lays out where the church is, where the principal legacy trust is, how it is interlinked with all these other underlying trusts and their unincorporated association operations or incorporated operations if you need those as well.
So bringing it back to basics, if someone was like listening to today's call and probably a little bit overwhelmed with the fire hose of like new information, like if you're just dipping your toe in the water of like, right, I need to get asset protection in place. I need to maneuver myself more into the private. You, would you agree that the NLT is the perfect foundation for that, just to from
It,
simplicity?
it's it's quintessential, Bradley, as we all know here. But yeah, for all of us here, you need to understand that you got to do something about the situation we're in. We
Yeah,
all look out at the world and see this vast array of, political dynamics and, folks that want to enslave us to the grave. And
Yeah.
with the recent tragic events that happened, there's a lot of views on what's going on there. There's not a lot of truth as to what's being revealed.
Mhm.
So the government, in my view, seems to be doing the same thing it's ever done. But the government is not supposed to be part of our private lives. So it doesn't matter who's in office or any of those things. The government should exist to keep free people free. And we, as law-abiding people, we have every reason to instruct and demand of the government, hey, don't tread upon my rights. I'm operating out of a natural law trust. I'm a private man or a woman. And your limitation, your jurisdiction, if you will, ends at the door. You're not invited to be a part of my private operations. But absolutely, Bradley, we must begin with the natural law trust because it's the simplest way to protect your assets. It's an irrevocable trust, so it has viable existence separate and apart from you under legal principles. It's its own legal entity, and that's what we want to do: is separate all our sort of living out of a social security number construct, which is fake to begin with,
Mhm.
and create some institutions that we have complete control over. And yet, that institution can protect against ne'er-do-wells, creditors, and others who want to sort of take and take and take from us. And that includes taxation. So, yes, the first principle is to break out of the system by forming a trust. The natural law trust is a perfect start for sure.
Yeah. And no one's coming to save us, right? We've got to save ourselves. So
Well, and there's a movement of us, but absolutely we have to take ownership of our own, sort of private domain.
yeah.
I tell my clients all the time, even when I form an unincorporated association for you, don't make the mistake of going to your local county registrar or whatever it is, where they say, if you want to use a fictitious business name for your organization, you need to publish it here, and then the name is good for 5 years. We don't need their permission. We operate under common law principles of trademark. Under
Yeah.
common law principles of trademark, guess what the easy workaround is for going out and getting a fictitious business name permit, if you will? It's simply to publish your website. It's to
Yeah.
put your name out in the ether. It's to start doing business as who you are. Take possession of the name. All these are trademark, common law trademark principles. So,
Yeah.
uh, absolutely.
You
Amazing.
have what I call sovereignty consciousness, Jude. Uh, there
No,
were
I appreciate that coming from you, Tonson.
no less than 6 U.S. Supreme Court cases that said Americans are sovereigns without subjects, but very few live it. Very few seem to have awakened to that and operate that way. So
Well,
it's a great joy and honor to get familiar with you as a member of our family.
Well, I so appreciate that, Tonson. And I am a member of the family. For those of you that I didn't mention it to, I'm a client of Brilliance in Commerce, and I've learned a tremendous amount from the resources available at the website, the NLT among them. Uh, but I'm humbled by that remark, Tonson. And, it hails back to something you asked earlier. Have we had victories in this space? We are having victories on a daily basis. I have
Beautiful.
clients that will reach out to me and say, hey, I followed your methodology, for example, on taxation, and I got a letter back from the IRS. Okay, well, show it to me. And I'll read the letter and I'll say, well, congratulations, you won. Yeah, the IRS and the ABC, the alphabet soup agencies out there, they're not going to congratulate you when you prevail. But when we successfully get them to push back, they're going to use very subtle language to make us think that maybe they're not going to let this go. And oftentimes I'll tell the client, hey, let's write back and tell them, hey, there's some ambiguity in what you wrote. So before I let this go, I need you to make sure that you confirm for me you're going to let this go. Sometimes we have to do that, but what it really what it really highlights is that there just is no path that has been wide is the way and broad is the path that leads to destruction, and small is the way, narrow is the gate that leads to life, and there are few that find it. That's sort of a truism in life, because in this path towards freedom, there isn't a scripted path. There's not a path that our CPAs, our bar licensed attorneys that are not awake. I don't refer to myself as an attorney. I refer to myself as a lawyer. Although Tonson did catch me for using ESQ after my name as a title of nobility recently, but I'm continuing to be enlightened on these principles myself. But what I can tell you is that there is no scripted path. There's no lane for us. We actually have to carve out our own path because there simply is no guidance other than looking into, for example, what Tonson just mentioned about U.S. Supreme Court cases that make it very plain. We are sovereigns. We are the offspring, if you will, of the creator, which the founding fathers referred to as the one that endowed us with certain inalienable rights, among which are life, liberty, and the pursuit of happiness. But because our governments have lost their way, there simply is no guidance, and we have to create that path forward. And I think that's what a sovereign does.
Yes.
So I have a particular question, but first, George, I noticed you raised your hand earlier. I don't know if your question was asked or not. If you still wanted to ask your question, just go ahead and raise your hand. Oh, there it is. All right, so I'm going to let him go, and then I'll ask my question. Go ahead, George. You're
Oh, okay.
unmuted.
Okay. Just my question was simple. Since you're an attorney or lawyer and we're creating unstatutory entities like trust and unincorporated associations, uh, you being a lawyer, does that taint it or does that make it invalid? How does that work?
George, I so appreciate the question, brother. When I first came into this movement, uh, it began with my theology back in about 2007. And it was really my wife that sort of turned me on to like, let's look at things anew. And from that time forward, George, I began to question everything. And of course, obviously, that led to the practice of law that I'm involved in. And when I first came into this movement and was seeking for answers, desperate to know truth, um, I got a lot of flack from folks, and it got nauseating how often I would hear people talk about, well, the lawyer, you can't go to attorneys, they're in on it too. They are they are assets of the crown. First of all, lawyers are not all they're licensed by the particular state in which they practice law. This is the only way that I know of right now. I believe that there is a path forward eventually for a free man like myself to represent others that don't have a voice for themselves. And George, that's why I do what I do, because I know that among our people, there are people that don't know how to construct the argument, or maybe quite literally, they just don't have the capacity to stand up for their own rights. So I believe in that. And I believe that I'm called to this unique position for a unique period in time where we're all trying to find more and more freedom. But how do we keep the things that we need? If we're people of big industry, big business, and we're making an impact on the world, or our ministries, whatever the case may be, in which we are making a difference in the world, we can't simply, by wanting to exit the system, forfeit all those things. They stole everything from us to begin with. So how do we maintain the position that we have? We have to do it in some instances through operation of law. That's where I come into play. And with regard to this notion out there, the lawyers are in on it. I'm just telling you the truth. It's not true. These things are not taught in law school, George. They are hidden from us, much like Western medicine and medical doctors. They are not taught truth about holistic medicine or other modalities that don't require surgical procedures and pharmaceutical drugs. It's the same thing with the practice of law. We are taught how to continue to make our clients compliant sheep that simply tether onto the system, pay their taxes, stand in line, take instruction from everyone. But what we know in this space is that a free man does not ask for permission. So what is my involvement as a lawyer on your behalf? What are the implications of it? It's as a matter of law, we have the upper hand. And sometimes you need a lawyer to get that point across through my documentation process, which is very robust. But my license doesn't come into play. It's simply a question of, as a matter of law, do your organizations and does your methodology for how you live out of the NLT, does it pass muster because the organizations were properly created? That is, again, established as a matter of law, and that's so that we can communicate that information to the Babylonian system simply to stay out of our affairs. And again, doesn't matter if your lawyer is awake or isn't awake, their law license and their practice of law has nothing to do with that. I hope that helps.
Jude, I hope you've heard why attorneys are buried 12 feet deep when they die instead of the usual 6 feet, like most people.
Oh, I bet I've heard this in the past, Tonson, but I know you're going to remind me.
Because deep down, they really are good people.
Yes, I had heard that one. It's been a while. That's a good one.
Okay, thank you for that previous answer. My question is, in the case of somebody like me who does have an LLC that was organized by a natural law trust, um, and fortunately, I only just did that this year, but it's the first time I organized an LLC. Now, next year, when tax reporting season comes around, as I understand it, LLCs have a reporting responsibility. They don't necessarily have a paying responsibility, but they do have a reporting responsibility, whereas the trust does not. Is there anything that I would be supposed to be doing as far as that goes, in as much as reporting what the LLC needs to be reporting, but still somehow not paying income taxes?
Well, your question sort of touches on a couple of principles. Number one, are you tax emancipated in your Social Security number?
I've done the revocation of election for myself, yes.
Okay. And is your LLC a pass-through organization, single member entity? How's it taxed?
Single member LLC with the trust as the organizing member.
Okay. So that organization is a pass-through entity. It's sort of a disregarded entity. The money flows to you in your SSN capacity, if you will. Taxability for the LLC is not an issue because ultimately the one who will answer for the tax is you in your SSN. But because you're emancipated from taxation, you're exempt uh, pursuant to your revocation of election. There's no taxability. Now, the IRS, at some point, the more and more successful you become, Seth, and the more of an interesting target you become, they can come out and harass you. And I'm available for those situations. I've got a lot of experience with working with clients that are in just that situation where, they've been going along for years, just fine, operating out of their trust, but then suddenly something gets on the radar, a 1099 report or information returned filed by a third party against you, and suddenly the IRS or another state entity, state revenue office is trumping up charges and saying, hey, you got to file a tax return now, and you'll have to reinforce your revocation of election, possibly. I've seen those cases come through. But in the situation you just described, the LLC passes through to you, you're tax exempt, you're free.
All right. So just to make sure I completely understand, there is no such paperwork that the LLC has to file, like not even like an information filing or anything like
Oh,
that.
oh no, I'm sorry, I didn't address that. With any entity that is incorporated, that's going to be an LLC, a partnership, a C Corp, S Corp, any of a number of different types of organizations. If that organization is tethered to the state, then it is a creature of statute. It is a creature of the state. So unfortunately, what that means is, yeah, you need to be in good standing. You need to comply with the reporting obligations. So, for example, in the state of California, where I'm in San Diego. If I had an LLC, I'd have to report to the Secretary of State anytime I wanted to make a change in business. I wanted to add more members. I wanted to, or if I even want to close the business down. I can't do that without seeking permission of the Secretary of State. And this is what really irritates me about, hey, we're free people. And yet the only way to run business as far as they're concerned is by asking permission of the Secretary of State. So when you have created that entity, unfortunately, yes, Seth, you have an obligation to keep it in good standing by jumping through the hoops and making the reports. On the other hand, why not move it out of an LLC, form an unincorporated association which has the backing of federal law to say, hey, these organizations are recognized at law as viable business entities. You got your own EIN with it, but you're not tethered to the state. You're not incorporating with the state. And therefore, you don't have to do what the LLCs and other incorporated entities have to do, which is to create a routine reporting mechanism.
That is definitely something I will take into consideration. I originally formed the LLC because the idea when at the time when I did it was that I was working towards being able to get a business loan. Whether or not I'm still actually going to go for a business loan, I don't know. And if I decide not to, I very well may go a different route from the LLC, and I'll have to make that decision before the end of this year. Um, but as another question, just hypothetically, let's say I remain an LLC. Um, I have employees that also don't want to pay income taxes. And one of them still has to do their revocation of election on that end. But when an employee doesn't want to pay income taxes, some of the income taxes are shared between coming out of the employee's pay and the business paying on some of those. Um, so when you have an employee that doesn't want to pay income taxes and they've successfully done the revocation of election, what does the business need to do on their end as far as the other taxes are concerned that the business would otherwise be responsible for?
Well, it's a great question, and employees or employment relationships are very complicated, and frankly can ensnare a lot of our operations. So it's a really great question, Seth. Something that a lot of my clients have to contend with. What do you do when you have employees? And obviously, if you have more than 15 employees, you're in a different category altogether. I assume we're talking about less than that.
Yeah, right now I only have one, but I'm looking at hiring another.
Okay. And the larger your operations grow, you're gonna surpass certain thresholds if you go beyond 15, where now you got other reporting responsibilities under geez, what's the employment the federal employment law, whatever. We'll leave that. We'll not talk about that. But employees can potentially ensnare your operations if they're W-2 employees. Are we talking about 1099 or W-2 employees?
It would be a lot simpler if I did 1099. But then, so the thing is the legal definitions of an employee is, if they're a 1099, they're an independent contractor, which means I can tell them what to do, but I can't tell them how to do it. And I do want to be able to fully and completely train my employees in how to work a certain way, which unfortunately makes me have to call them an employee. So the only options I have left are W-2 employee or W-8 employee.
Okay. Um, and either way, when it comes to identifying what a true 1099 independent contractor is a matter of law. So there are several factors to consider. But even if you control the methodology for how the business is done, because you got a proprietary formula, for example, obviously, whether your employee is a full-time W-2 employee or an independent contractor, they got to get the formula right. So you can control certain aspects of the job requirements, if you will, without also incurring that employment relationship status. Um, Nevertheless, yeah, it sounds like you've already crossed that bridge. You've looked at some of those things, and you may have to have employees. So I try and encourage my clients all the time, avoid having employees, hire independent contractors. It's not always possible. And sometimes, depending on the industry and how much liability it may incur, we might want to segregate and separate payroll, for example, and just your employees into a separate category, either into an unincorporated association owned by a trust, or we might have certain regulations that are applicable to that particular industry. And so we want to have an LLC or S corporation or something else. But every situation is different. It's not a one size fits all. And it sounds like you're already encountering that, it could get pretty complex. But we'd have to kind of look at what your industry is, get more details about that before sort of just giving you a one size fits all solution, because it's not that easy. You really do need to pay attention to what the potential liabilities are. And again, with employees, typically the reason I don't want my clients to have an employment class within their organizations is because employees can file suit. They can get fickle. They can get upset. They can decide they didn't get a fair bargain for their deal. You can have an independent contractor relationship in which you are exercising too much control over when they show up to work, where they work. You issue the computers, you issue the standard operating equipment, whatever. Now you're exercising control in an employment capacity, even though you've dubbed these employees as 1099 contractors. So there's a lot in sort of doing a deep dive to figure out how your operations are structured before you can make a really fail-safe plan, if you will.
I could probably
Jude
pick
and
your
Seth,
brain about this the
thank you,
whole
Seth.
meeting, but
Thank you,
go ahead,
Seth, for those
Thompson.
questions, and you may be asking things others have wondered as well. So this could be useful for everyone. I wanted to skip ahead just to one of the questions in the tax, and we can go back to the ones in the chat that I've skipped over, but this one regards Canadians. And Jude, some of the people are saying, do you help Canadians? But I wanted to answer this question of a Marival, a Canadian here trying to plan forward how to embellish our LLC via small home business, have purchased an NLT, but stumped as to how to interface this. Any suggestions? Well, first of all, as a client, Marival, you can consult Bradley anytime because you're a client. Number two, it's very simple. All you do is assign, say, up to 95% of the income of the LLC to the trust, and Bradley can assist you with that.
Yeah, to add a little bit more to that, I'm not working with Canadian clients at this point. I've got clients in other countries. But what I want to emphasize is that the natural law trust operates internationally. So that's a good thing. Any constitutional form of government, any country that honors a constitutional form of government, you can do business with your trust. You may have to have a local person involved in opening bank accounts, for example, or other things like that. But the trust itself can operate internationally, the common law trust. And that's the benefit of being non-statutory. When you have a statutory trust, that trust cites to the California code on trust formation, for example. And now you've tethered yourself to that location, if you will. And if you want to do business with that trust in other places, then you got to potentially ask for permission of these other jurisdictions through as being a foreign entity. With regard to LLCs in Canada, I am not adept at the laws of Canada and formation of business entities there. With the unincorporated associations, though, again, I think that there's got to be some methodology for considering that as a Canadian citizen. And I would encourage you to really look into what is the law of unincorporated associations, unincorporated organizations under the law of Canada. And it's going to follow a similar sort of path as what I've described under U.S. law, if you will.
Thank you. And yes, as I said, for anyone who's a paid trust client, Bradley is very international, aren't you, Bradley? And you've been helping people very well with their trust setups and business arrangements with the Natural Law Trust in foreign countries.
Yeah, Amival and I have been in correspondence about this, so yeah, we can circle back to that anytime you're ready.
All right. So I want to thank you again, Jude, for answering my questions. I'm going to move on now to some of the other questions. This one's from Elizabeth. In regards to church and state, is not everything under Roman civil law, which would then collapse the status of a 501c3 at their discretion? I'm not sure if I read that right. Did that
Who
make
was the question
sense?
from, Seth?
Elizabeth?
Elizabeth, thank you for the question. Here's the important thing to understand about the church. It is not a physical institution. It's deemed to be eternal. So regardless of what your beliefs are about, its Roman origins or anything like that, here's the important thing to note. It isn't so much what we regard as the church, but what we know the Babylonian system to regard as the church. And they give complete deference under Western law, any Western civilization that has recognition of the church. They give it its own ecclesiastical form of governance. So people don't come to me because they follow a particular religious belief or anything like that, whether including roots in Roman Catholicism, for example. The fact of the matter is, it's embedded in the code, in the Internal Revenue Code, in the law of the land, U.S. Supreme Court doctrine, etc. And what it does is it creates additional securities to freedom for free peoples. I maintain that the church, in all of its forms, has been stolen away by ne'er-do-wells, by infidels who don't actually believe the things that they preach. But the church itself, for those of us who are spiritual in nature, eternal beings, we know that we have We have an eternalness to our nature. We're connected to the ether. Whatever your belief system is, the fact of the matter is that we're the true worshipers. We're the true believers. And the church should be used by us to protect our culture, our society, our communities. And the most important thing to understand about how we're using this institution, this so-called 501c3, by the way, that doesn't define who we are. It's simply we are communicating to the system, hey, we are a viable institution. We're called the church or a ministry. We're spiritual people, and here's what we do. And when the bank says, well, we don't know how to open a bank account for you. Oh, well, here's our EIN, and it's regarded under Internal Revenue Code as a 501c3 nonprofit. So what I'm trying to explain is that the organization itself is highly protected by American jurisprudence. So we position ourselves to leverage that power for the benefit of our continued freedom. I hope that makes sense.
Yes, thank you. And I think another way Elizabeth's question could be asked is, we've been recommending that churches use a natural law trust instead of a 501c because of the fear that if they say things at the pulpit that the government doesn't agree with, they could collapse the 501c. So it raises the question of how their freedom of speech is protected.
And that's a great wrinkle on that. I may have missed that, Elizabeth. And to answer that question specifically, you are not under the microscope with the government if you are a 501c3 with a 508c1a designation as mandatorily exempt. Because under 501c3 law, every organization that is incorporated, if you will, as a 501c3 entity, they have to go through an application process, which is I referenced it earlier, IRS Form 1023. Take a look at that online, and it walks you through a series of questions. And one of the requirements of being a 501c3 that registers with the government and that reports to the government and that does its annual tax returns on Form 990, et cetera, those organizations give up certain liberties, certain freedoms. So yes, their freedom of speech is partly curtailed because you can't discriminate against certain individuals. You can look that up and figure out what I'm saying. But that law does not apply to the church that possesses a 508c1a mandatory exemption status because it never has to fill out Form 1023. And that's the rabbit trick. That's what the IRS, that's what the government does. They get you to fill out their forms, and by so doing, you're entering their jurisdiction. You are literally giving away your freedom by filing forms, by signing off on documentation that in some instances say, I'm a U.S. citizen. The person signing off on this document is a U.S. citizen. Okay, there's all kinds of ways to fill out these forms if you have to do it. But I maintain there is no such reporting requirement. The only interaction that the 501c3 church with the 508c1a mandatory exemption status does in terms of so-called registration is to submit an application for an EIN. And that involves no giving away of freedoms. It's simply the lowest common denominator for any organization that wants to do business in the world. If you want to be able to open a bank account, you need an EIN. They have left us no reasonable alternative. But beyond that, there's no more reporting. So there is no loss of freedom of speech, freedom of the ability for your organization to discriminate against those who do not adhere to your belief systems. You don't have to hire people that don't believe what you believe. Like that's the whole purpose of the integrity of the church, of your institutions, that you keep the culture, the teachings, and the philosophy that underpins your movement.
Very good.
So I'm actually a bit confused there. As I understood it, 501c3 and 508c1as are separate entities, and that if you become a 501c3, you're giving up your 508c1a status. But you're making it sound like you can create a 501c3 and maintain your 508c1a status.
It's a great question, Seth, and it's a misnomer. This is a fallacy. It's a myth. Okay, so I want everybody to hear this. It's very important to understand that a 508c1a church is not a self-standing operation. Here's what I mean by that. You can't go to the bank and say, I'd like to open a bank account. And by the way, banks love to do business with churches because they're cash heavy. Okay, I know that because of my client base. In any event, You can't go to the bank and say, I'd like to open up a 508c1A. Did you know that, Seth?
I kind
You
of
know why?
assumed, yeah, because you don't have a tax identification number for it.
You have no tax identification. You need it. Why set up a church if you're not going to? Well, if you want a bank through your organization, why set it up under your social security number? It's doing a DBA. You're just drawing more liability to yourself.
Right.
So we institute the church because it is a separate protected mechanism under all constitutional legal principles, freedom of speech, ecclesiastical self-governance, autonomy from the state, et cetera, et cetera. You don't get that as an individual. Okay. So yes, we want an EIN. But the reason you can't go to the bank and ask for a 508c1A church bank account is because they don't know it. It doesn't exist. And here's why. 501c3 is the classification that applies to the 508c1A church. Here's what I mean. 501c3 is the law that says in the world of all the people that the organizations, the institutions that the IRS loves to tax, there's a body of you out there which will receive 501A status. 501 simply lays out that there are organizations that are tax exempt. And then there are multiple causes, 501, A, B, C, all the way through. There are like 21 different organizations that are called out in 501 law. But all that 501 stands for is tax exemption. Now, fast forward a bit to 508 in the same statutory construct, and it gives more illumination or definition to 501c3. 501c3 says there are organizations that exist purely for educational, religious, charitable purposes. And that's what the 508 church is about. Okay. It's a charitable organization, it's a religious organization, but you find it in 501, and it's called out specifically as tax exempt. Again, fast forward to 508. And all that 508c1A does is modify the terms of 501c3 law. So in point of fact, the church that I'm talking about is a 501c3 church, but because of its 508 status is mandatorily accepted from reporting. So they're one and the same. A 501c3 church with 508c1A classification, which again means the church and its associated entities do not report a single thing to the IRS. They are not subject to its jurisdiction.
That clears my confusion up perfectly. Thank you very much.
Beautiful.
So Chris says, thanks for the clarification regarding potentially wanting to use a front-facing LLC for any instances of interacting with entities that need IRS interaction. My concern was that doing so would negate the sovereign, unincorporated nature of the trust, but apparently not. Is there anything you'd like to expand upon that with?
Absolutely. Whose question was that?
Chris.
Chris, excellent question. Please understand when you set up your NLT trust, it has its own EIN, and it is now under law considered a separate legal entity from you and from any other organizations that you found, create, interact with. So the existence of your NLT trust and owning interest in an LLC, for example, that doesn't disrupt the legal standing, the separate legal status of your NLT trust. Nor does the LLC, is it impacted by the fact that there's the existence of your NLT trust. They're two separately, completely different operations. So if you're ever audited by the IRS, they don't come after all of the organizations necessarily. They'll start with one because they are limited to that silo. Is this operation functioning as a proper LLC? That's a separate question that cannot be sort of just drug in by the mere fact that you happen to be an officer in the LLC or a member. And then, oh, you're also wearing a different hat with this trust that's out there in the ether, and you're a trustee there. Oh, well, there must be some collusion there, so we're going to investigate it all. That's not the way it happens. The IRS goes after institution by institution. And if it should happen to find ties that are conflicts of interest or self-serving, yes, there might be further investigation. But ordinarily, the fact of their existence does not create a liability for either. The LLC is taken on its merits, as is the NLT trust. I hope that helps.
Yes, and the NLT cannot be audited, but they could audit the LLC. But the way that we hopefully prevent that is by not giving 100% of the LLC's assets to the trust, because that would raise eyebrows, probably trigger an audit. eventually. But if you only give 90, 95%, it's done all the time by corporation. It's done every day. It's very common. It doesn't raise any eyebrows.
Well said. And that sort of hails back to what I was talking about with the front-facing LLC, because you want to put payroll out there. You want to skim out of all of these organizations and send them up the chain into your NLT trust. This is why you don't want the NLT trust too much involved with your customer base, with other operators, with transactions, etc. Keep it hidden, keep it tucked away. It's your proprietary family secret.
Yes.
Run your life out of that trust. But you want to run these other organizations so that they create a consistent stream of commerce from themselves up into your NLT trust and into potentially a legacy trust that is also an NLT. Don't get lost on the terminology I use when I say legacy trust. I'm just talking about that one trust where that's your nest egg. You're making sure that this is where you are saving for the future, for your heritage, if you will, your heirs.
Yeah.
One of the things that's interesting about the NLT trust is that you can use one of those as a front facing, just don't put the assets in it. Put that in another trust. So as long as you keep those separated, you could use one at the front and have another one holding assets in the back, and that would probably work as well.
Absolutely. Well, it's about time we heard from you. Thank you, sir. I agree 100% that, and that is what I'm talking about. You're structuring your organizations in such a way that if you have a trust that is operating that owns an unincorporated association or has interest in an LLC, don't make that your last stand. Create another NLT trust above that as your legacy trust, so that the trust that is the operating trust, let's call it. It's creating a pocket of wealth for potential liability. So let's not let it answer for that. Let's create a relationship with another trust that is totally insulated from doing business in the world, if you will.
That's called layering as part of estate engineering. We heard in the early 90s that the Rockefellers had some 7,000 of these non-statutory trusts. And Will
I believe it.
one who plans to have at least hundreds of them with what he's building.
I like your style, Will.
Well, the idea is you put a project under its own trust so that you don't contaminate others. If you have a project that might go south on you, you don't want to contaminate the rest of your assets. So
Absolutely.
it's a matter of liability protection, really.
It really is. Listen, on the issue of limiting liability, it's an important construct. It's why we incorporate with the state. Do you know that the reason we pay these goons and these mobster types an annual fee and ask for permission to do stuff, we pay them protection money? I'm talking about incorporating. The reason we do that is because the Business and Professions Code of each state basically provides that if you do that, if you come and ask us nicely, Mother State, Secretary of State, and you register with us and you pay our fines and fees and penalties and dues every year, and you keep us informed of what you're doing, then we will bless you with limited liability under our laws. That's all. That's all we get out of that construct. Well, for those of us in this space, we've awakened to the fact that we don't need the state to protect a private man or his assets. What we have instead is trust law, which goes back thousands of years to the Greek and Roman empires. Okay, so trust law is viable. It's older than this country, if we know the age of the country. In any event, the trust itself becomes the limiter of liability. The state has been rendered completely useless for us. That's why we don't need those statutory trusts. We don't receive any benefit from incorporating under the state statutes. We are simply establishing a trust under common law principles, trust principles, and under viable trust law itself that is age old. It says anything inside the trust is protected by the trust itself. So you can't, simply because Will operates another trust that has nothing to do with the assets in this trust, let's go after that second trust that Will is also a trustee over. That's not the way it works. You're limited to what's inside that trust, which does bear an important next point here, which is if you're building up your NLTs to have tremendous assets, thin them out. Create a second and a third layer of trust operations. Don't have real estate in the same trust as you have your investment in your investments, your Bitcoin or other crypto. Because what you're doing is you're creating a big pocket of wealth inside one trust operation. And if anything, for example, look, I'm a lawyer and I have to tell you, I deliver bad news to clients all the time. Okay, if you have a house with a second story deck and your kid invites, all his friends over for the weekend, somebody falls off the balcony and dies. Okay, those things happen in the world. How are you prepared for that liability? Because if you didn't have enough insurance to cover, let's say the person that died was a 19-year-old blossoming college student with the world ahead of them, that they had great future earning capacity. Now that's taken into account in terms of what are the damages going to be in this liability. If that exceeds the insurance that covers your home, now the assets that are inside the trust may potentially have to answer for that liability. So why would you have your crypto in there? Move the crypto into a separate trust. Same thing with other large operations. If you're generating a lot of wealth inside these NLT trusts, consider thinning out the herd and separating your things like Will is going to do with 100.
That's the asset protection cardinal rule. Never put all your eggs in one basket.
Mhm.
Yeah, absolutely.
And it becomes particularly important when you look at certain activities that may have inherent higher liabilities. Like if you own an airplane, for instance, and somebody might ride on that airplane, you better have that in its own trust, because if it goes down,
Absolutely.
you're toast, right? So just an
You're exactly
example.
right, Will. I've got clients that have operations that are sophisticated enough where let's separate equipment from excavation, separate excavation from your your independent contractors, the folks that are going to be doing these construction operations. Separate out logistics, transportation, delivery of product, formulation, intellectual property. I mean, these are all part of the strategic ways that we got to think through. Hey, how do we limit liability against any one part of our operations? And it also applies to us in the home, being wise stewards over what we've been given to be able to pass on a legacy to our loved ones.
And I think
All
Bradley's
right.
prepared to do a multi-layer approach if needed, right, Bradley?
Yeah, that's one of the next questions actually, so it leads in quite well. Taylor's asked, how would it look setting up a trust network with an LLC, unincorporated association, or private members association and sub-trusts all under an umbrella trust? So that's exactly what we're talking about, right? Which is, you have your master trust or your legacy trust at the top of the pyramid, if you like. And then underneath it, you have sub-trusts for each of your asset classes. So, you don't necessarily need to have separate trust for your Bitcoin and another for your XRP. Of course not. No. But if you're owning real estate, then you definitely want that because there's a liability component to it, as Will said. So that needs to be in its own trust. And certainly if you're considering putting vehicles in a trust, they absolutely have to be in their own trust because they are removing liability, particularly if they're your daily drivers. Different story if they're in a storage unit somewhere because they're a classic and you're not driving it. But anything that's got any kind of liability implications, it's all about siloing them and insulating it yourself. So yeah.
That's right. And so with regard to the apex predator, if you will, the legacy trust at the top of the organization, instead of the only place I would depart on the notion is that it's not really an umbrella organization to the extent that it protects the rest of the organizations below it. It's more of an inverted model where everything's meant to streamline up into it to secure and protect all those lower level assets from being potential targets for liabilities. And you do that by getting it up into the legacy trust at the top.
Makes
Yeah.
sense. Thank you for that clarification. Gina is asking, is it necessary to file an ROE knowing what we know about the dissolution of the IRS and Washington, D.C., the federal government?
Well,
I'd
can I
still do
take a
it
stab at
anyway.
that? What'd you say, Bradley?
So I'd still do it anyway, right? What harm can it do? Even if the IRS gets shut down tomorrow, you've
It's
covered
it's a
yourself.
statement, folks. I have clients ask this question all the time. Well, if I'm doing all these other things, maybe I don't, need to do revocation of election. If you're a patriot, if you're a revolutionary, if you are, somebody who promotes the ideas of freedom and like the real republic that this was supposed to be. If you believe in taking it back, then yes, I think if you have the wherewithal to do it, do it. It's a statement more than anything of who we are as sovereigns and free peoples, that we are intending for the world to know, the IRS and others, that it doesn't just apply to our businesses, to our trusts, it applies to us. Keep your hands off of our stuff. And I myself, even though you've given me a social security number and an all caps name, I am not going to let you use it to broker these black market exchanges anymore.
Yeah, it goes beyond income tax. It goes into identifying who you are in relation to government. And that has, I mean, vast consequences and benefits. There's no downside to it. There's only upside.
None. And listen, all the shenanigans going on right now with you know, uh, the what do you call it? The income tax and whether it's going to come or go. I maintain this, that first of all, that should have nothing to do with our private lives. Your private gains from your labor are inherent rights. They are not privileges that can be taxed. The income tax is an excise tax that applies to the privilege of being in close proximity through a working relationship for the government, state, local, or federal. And frankly, in 1939, with the passage of the Public Salaries Tax Act, is when the federal government said, "Hey, why are we taxing only a certain class of taxable income? Let's also include state government officers, anybody that works for the state." So it used to just be federal, but now it's anybody that works for the government. So it's I just think it's very important for us to make the statement that yes, we're not a part of that system. It's a public system. We don't have these public lives that are taxable in the way that they try.
Well, that's the issue, though, when you go to the Secretary of State or you're asking any state entity to say, I want your permission to exist, they'll say, oh, absolutely. Just pay me a fee every year. Right. Right.
It's ab-
And I'll be
Absolutely.
your partner. And because I'm a partner, you're now a construct of the state. Therefore, you don't have a choice. You're taxable. Sorry.
Right. Well, Seth may have that problem. There are some instances in which, depending on the nature of your industry, you may not have an option. But again, I maintain, give them the littlest, give them the crumbs. Operate that LLC with only the capital necessary to sustain its operations. Everything else, move out of that construct into an unincorporated association or into an NLT trust, and just don't leave anything left over for the government to say, "Oh, we see you made lots of profits this year." No, run your operations smoothly, leanly, and capitalize to the minimalist extent possible.
Well, that was the idea. I kind of still have questions regarding employee taxes, but I'll save that for another time. I got plenty of other questions from other people here. Another question from Taylor is trust can sue in their name, but the court wants a lawyer to represent the trust. How do we go around this?
Well, that's a difficult. It's why, guys. It's why I still have a law license. Not because I believe in licensure. I believe that my gift is ministry, and there will come a day when I can operate in these courts of law, asserting myself not as a licensed anything, but as a minister that is standing in the gap for my people. But when it comes to entities, any entity that is created in the ether, in the world, it's just it's a different beast. And according to their law, the statutory beast system law, yeah, they're going to maintain jurisdiction, and that the only way that anybody else can speak up for this entity, your trust, is through representation by a licensed attorney. Now, there are people out there today, probably on this call, that are figuring out ways around that, where you're basically asserting constitutional law principles, common law, getting out from maritime law and all this other stuff. But it is a maze. It is a very difficult prospect to try and undertake that. And usually where we get tripped up as freedom seekers is not on the merits of the law that we're advancing, but on how exactly to raise your issues, the points of law. We get tripped up on procedural law. So often we might come into court and say, well, I'm speaking on behalf of this entity, and here's all the legal authority, and here's my affidavit of truth, and we spill out the beans. And all that the court wants to know is who are the parties. And that's because they trick us, with this dog Latin and procedural law, to not really understand that there's going to come a time and place for you to present your evidence, but you got to jump through all kinds of procedural law hoops before you can ever get there, and certainly to get your day in court. But I maintain it's a very difficult thing to try and skirt around the idea of representing an entity or an organization such as your trust without legal representation. That's unfortunately the fix that they have on the system.
Jude, let me ask you just a quick question. So if someone is using, shall we say, counsel, okay, in a constitutional court, that's not necessarily a lawyer, a solicitor, an attorney. It's a counsel, right? So how is that different versus being represented by an attorney?
Well, it's a great question, Will. And the real rub comes down to, and how do you convene the constitutional court? Because typically what we're doing is we're being hauled into these courts of law, and these folks don't know the law. They don't know the law that we know. So how do you go into their territory and establish a constitutional court or convene a constitutional court? Even having the judge operate at your pleasure, if you will. They don't get that. They don't understand any of that. So it really comes down to the idea of our rights are often going to be railroaded because we're operating in their territory. Now, I think with the recent passage of a tremendous body of law by the U.S. Supreme Court on administrative law, the undoing of Chevron, and several cases that are coming in its wake, there is an awakening happening. And it's starting with the U.S. Supreme Court. It's trickling down to the federal circuit courts, the appellate courts as well. But it's going to take some time to get it to the state level courts. I'm involved now in two separate cases in a couple of different parts of the country where the states have railroaded on my client's ability to travel. Okay. Side road stops, revocation of licensing, ability to travel, being thrown in jail for long periods of time, warrants outstanding, whatever several types of issues like that. We know that we have solid grounds under constitutional principles, but the state courts give it no regard. If you try and show up as a sui juris litigant, if you will, an individual in their capacity as a man or woman, the court doesn't recognize that, and they'll exercise jurisdiction over you anyway. So the problem for us is now we have to spend the next several months, possibly years, unraveling that through involvement of the federal courts, or interlocutory appeals, or a number of different ways to do it. But ultimately, you have to show the court over time, you made an enormous mistake. It's appealable. You didn't give any regard to my rights as a man or a woman. You're using this false construct, all caps name and the social security number as a weapon against me. But again, like I'm saying, Will, how do you begin that process? Most of us don't have that kind of money or time to simply give to these experiments with the state courts, where you're going to get railroaded anyway, and you'll spend the next 2 or 3 years trying to demonstrate through the federal court process that they trampled upon your rights.
So it's easier to just avoid them altogether by staying out of their system.
Absolutely. The one thing I caution my clients all the time is stay out of court. Whatever it is that you're doing in your operations, avoid court process. In my fee agreements with my clients, I have a provision that says we're not going to court. If there's any issue in dispute between us, we're going to resolve it through arbitration, and it's going to be binding. That's written into my contracts because I don't want to be in the courts of law, and neither should any of us. That's not the place for free people. That's a place for jurisdiction to be tested, and potentially so many traps and pitfalls that we might end up giving it away.
Okay. Thank you very much. Victoria asks, what about when you have asked for confirmation that you are tax exempt for a foreign EIN and they say that you are not, and then for another one they don't reply?
Well, the don't reply means you're partially winning. But how to get restrictions lifted once they've been imposed is a tricky matter because the IRS, they're like dinosaurs. They just don't move quickly. And sometimes it requires the threat of a lawsuit. I just finished saying try and stay out of court. But guys, there are times where you have to threaten a lawsuit. And I don't mean going to U.S. tax court or any tax court for that matter. Don't go to administrative processes. As a non-taxpayer, we have rights that are outside the scope of the Internal Revenue Code. And as such, we can sue them in the federal courts of law. Okay? And that's what I recommend is that sometimes, unfortunately, you're going to have to raise the stakes with the IRS or state revenue departments and let them know that they're violating your rights. You've sent multiple communications to try and get the point across, and they're still violating your rights. What options do you have left but to take legal action against them? You could write to senators and your state representatives and things like that, but that just doesn't seem to get a lot of traction. What really holds these people accountable is the threat of liability in a court of law. But you gotta have the right forum to go present your arguments in. Unfortunately, Seth, for that question, I don't have a more satisfactory answer than that.
Tonson's been through that. He understands.
Yeah, Jude, I had a victory in an Article 3 court in Washington, D.C., the federal court there against the IRS.
Was that the Federal Court of Claims?
No, just the U.S. District Court, because we could invoke Article 3 there.
Yep, absolutely.
It's on the website later. After, if you want, I can refer you to where it is on the website.
Oh, okay, that'd be helpful. Yeah, I mean, you're proving my point, Tonson. You're not going to find success in the state courts. It's trickling down. The state court officers, the judges, all of them are going to eventually understand that they cannot stop the movement of us. We are supported and backed by law. Gorsuch being on the court now and the great things he's doing, the turnaround against Chevron and the Chevron doctrine of the 70s. That thing is already a thing of the past, and that's only of recent vintage. So we're going to see a tremendous tide turning in our favor. But again, the wheels of justice turn very slowly. So if you don't have the appetite for a long journey like that or the money, the resources, just do everything in your power to stay out of the court systems. Otherwise, if you got the backing financially to do something like that, you might want to consider taking your case up into a federal Article 3 federal district court, or another original Article 3 court is in DC. It's called the Court of Federal Claims, one of the original federal courts, and it is specifically designed for citizens. And I know that word can be a lightning rod for some, but citizens to bring their grievances against the government.
Capital
And that's a
C
unique
citizen.
Say again.
Capital C citizen.
Yes,
But
exactly.
if you do win, don't expect them to say, you won, here's why, and we'll correct your status. You'll just probably never hear from them again.
No.
Well, they will settle in chambers. They'll bring you in chambers and settle that thing. There'll be an NDA, non-disclosure agreement. Yeah, we're going to settle this, but we need you to. They
Right.
can't let the rest of us off the
No,
plantation.
I don't want
Not
to go
that easy.
viral.
Right.
Exactly.
Okay, so Elizabeth asks, would you kindly speak to when or if 1099s are issues to the personal Social Security number after the ROE is filed? Are those just ignored and no tax filing is necessary?
It's a tricky question, Elizabeth. The answer is yes, they should be ignored. You've already made your statement to the IRS, and all that the 1099 is somebody, a third party in a communist form of government, your neighbor reporting that they paid you some money, and maybe it's subject to tax. That's all that it is. It could be corrected. Look at the 1099. It's got at the top of it a checkbox for corrected 1099. Yeah, I had a third party report that I made this income. I'm correcting the record. It's zero balanced out. So the answer is yes, you should ignore it if you have a revocation on file. However, understand that the IRS may come around again. I've seen it happen. Folks that have done revocations long hence somehow got on the radar with some other whatever, the 1099 or some other such thing. And the good news for us is you just go through the process again. Do what you did the first time with your revocation of election or however it was that you got them off your back. Sometimes you do need to remind them though.
Well, if it's a situation like Seth has, let's say I go to work for Seth, okay? But I don't want to do 1099 either. Can I do a contract from my trust with Seth's organization and bypass that?
Trust can contract trust to trust as a matter of private contracting. That's the government is not involved in that transaction. So yes, Will, that is an optimal solution. However, it requires that the person with whom you are transacting, Seth in this case, is going to agree not to issue a 1099. So it's a completely different situation. The 1099 is only in the ether when it's issued by a third party that paid you money, whether an employer or somebody else. In the situation with your trust to Seth's trust, that's going to be a matter of private contract between two honorable men. You're not going to issue a 1099. But
what
it does.
What about the LLC? Like if he's got an
the
LLC, does he have to issue that, or can he just say, well, it went to another EIN, but there was no 1099?
Well, the only reason that Seth would want to issue a 1099 is if he wanted to claim deductible losses against LLC income, so-called, right?
Right.
Seth could just as easily decide, you know what, I'm just going to pay this as a contract. So I'll give you an example. Well, when my clients pay me for my services, I provide them an invoice, they send in a check or, send payment, right? There's no 1099. And if they try and issue me a 1099, I'm going to fire them as my client. I don't want your 1099. Use my invoice as evidence of your losses. So in the same way, Seth, instead of issuing a 1099 from his LLC to you as an individual in your SSN, instead of issuing, you can simply tender invoicing to him and say, hey, Seth, here's the goods and services I'm supplying to you. Here's my invoice. Please pay on these terms. Seth has all the documentation he needs now to do exactly what the 1099 would do without issuing a 1099. He's got the receipts to list on his Schedule C or whatever schedule you have to list for an LLC to show that it sustained losses. There's no 1099 issued.
It's like paying an overseas contractor, right? Like, if you're running a web development business, for example, and you're hiring someone in the Philippines, you're not going to issue a 1099 to them, right? You're just going to pay their invoice, and that's the end of it.
You're going to get right. Now, if the IRS had their way, I mean, they dictate terms to you all the time. And for Will's question, they'd say, well, Will, if you're earning that income in your SSN capacity, then Seth has an obligation if he pays any independent contractor more than $500 a year or some obnoxiously stupid number like that, low threshold. They'll say, oh no, well, now Seth has to report that through a 1099. There's other ways of doing business. Call yourself Will DBA, Will's whatever it is that you're doing for Seth's LLC. But we just have to think more creatively than the system dictates we must do. And by the way, the 1099, just to be clear, the issue of ignoring a 1099, I'm talking about when you have revoked election in your Social Security number capacity. I'm not talking about trusts or unincorporated associations or LLCs. If those entities that are separate and apart from you realize 1099s or other documented income, you got to do something about it. Sorry, Thompson.
The system can't police all of us, so one of their tricks is to get us to police each other. So if we refuse to police each other, their system collapses.
Yeah, Thompson, absolutely. Even look, let's even say, Will, in your hypothetical, Will pays you, and never issues a 1099. There's no invoices even exchanged. He's just paying you money. That's not on the radar until there is somebody that decides to issue a 1099. And even then, just because the IRS has a 1099 doesn't mean they're going to do something about it. How many times have you gotten a notice from the IRS that says, "Oh, we see that in 2022 you collected whatever, and we think that maybe you need to file an income tax return"? I've had clients ignore that letter. I don't necessarily suggest it. I think you should do something when they come to your door. But the IRS doesn't, it's not like a system that just automatically triggers itself. No, somebody at the IRS, some low-level lever puller has to send you a letter, and then they have to start threatening assessments. And then all of this gives you 30 days, 60 days to respond, et cetera. So there's a lot of opportunity for the system to collapse on itself, and you're never on the radar. But once you are on the radar, that's when you start having to decide what strategy you're going to employ to get yourself out of harm's way.
Over the years, I've had natural law trusts become agents for sales organizations or affiliate, and it received commissions. 1099s were filed at the end of the year. I didn't respond to it. I didn't do anything. The IRS never came and said, "Where's the tax return?" Nothing. There was
Yeah.
no consequence whatsoever.
Well, they probably saw the fight coming with you, Tonson, but your point is well taken. If they're, yeah, I'm sure. Yeah, but it bears out what I'm saying, which is just because there's a 1099 that's been issued doesn't mean you have to
No,
immediately spring to action.
I just
It
put
may
it in
never
a
come
round
around.
file.
Right.
Put
So
it in a
as I
round file.
understand it, just because somebody else files a 1099 for you to the IRS and you receive that 1099 documentation doesn't necessarily mean you have to pay income taxes on that, right? You don't actually have a tax paying obligation until you file something with the IRS
Right.
obligating you to that amount. But I
Yeah,
have a follow-up
voluntary.
question. I have a follow-up question on that. So, say you've done your revocation of election and say you've gone through, it's more of a question for you, Tonson. Say you've gone through the process to become a state citizen as opposed to a U.S. citizen. Anybody that you're going to work for that wants to file a 1099 for the money that they pay you, they want you to fill out a W-9 form. And when you go to sign your name on a W-9 form, it says in small print under there, under perjury, blah, 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 whatever, you have to be a U.S. citizen to sign this form, basically. And if you sign that form and you're not a U.S. citizen, you're committing perjury. So, as a state citizen, can you or can you not still fill out that form?
No, and I would refuse to. And if the independent contractor or employee wants me to, I'd say, "Have a nice day. Go
Okay,
somewhere else." I'm not going to sign anything like that.
right.
Jude, what do you
Okay.
think?
So
Yeah,
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 that answers that.
we do have issues with W-9s, right? Like if somebody wants to engage business with your unincorporated association or a trust for whatever reason, then you may be asked to sign a W-9. And don't do the online forms. Demand a hard copy so you can strike through the language that doesn't apply. I mean, just strike out US, the
Yeah,
district, right? Yeah, just refer to yourself as what you refer to yourself, sign off, and without prejudice. I know
yeah,
people like to use UCC 1308 and other types of things. I mean, if
right.
you try and keep up with all the developments at law to protect yourself, you could just not have enough space to write it all in. If you write without prejudice, it simply means, and if ever
We
this information is used in the future against my better interest, I reserve the right to argue based on whatever arguments you raise against whatever it is that you're presuming this form to have spoken for, because
Right.
it's only being supplied so that somebody knows, yes, there's a real EIN number out there or social security number.
okay,
And you'll see
that's
those
really good
things
to
come
know.
up, even if you have, sorry, Seth, even like, let's say Seth's doing podcasts or something, and he's broadcasting on YouTube and Rumble and whatever, that kind of thing. Those organizations are going to ask you for a W-9 at some point. Like if there's certain revenues that they're giving you, they're going to ask you,
Precisely.
even if
Right.
you have a trust, they're going to still say, we need this, right? So
Right now we're
what
selling
do you
books
do in
on
that
Amazon.
situation? I mean, that's a question.
Well, it's a good question, and like I said, so I have instructions on my documentation process for clients where I say, hey, if you're asked to fill out a W-9, don't be scared of it. Just know how to do it. And here's the information to fill out. Know what organization you're dealing with. But when it comes to signing off, strike out. There's like 4 or 5 different bullet points on the. Actually, I may have an example that are on the form W-9. Here you go. No, I don't have it on this form, but basically it's really important to read those 4 or 5 bullet points before the signature and strike out everything that does not pertain
I
to
can
the
provide that
transaction.
for any of our NLT clients. If you request it, I can provide that. Now, Jude, thank you.
Excellent.
Yeah.
All right, moving on to some more of our audience's questions. First, Gina Marie says a big thank you to Bradley for his time and knowledge with helping me move forward with my natural law trust. Still learning. I highly recommend his offerings at BIC. And Amerival Duplanty says, thank you. So a third entity is necessary. An unincorporated business needs to be in the LLC/NLT structure too.
I'm not sure I understand the question without more information.
I think she's
So,
just wondering, like, if she sets up an unincorporated business with or an LLC with an NLT structure, does it need to be like within one or another of those?
May I just say that she's already acknowledged that she can consult Bradley on that. So Bradley Amerival is looking for some estate engineering from you. So
yeah,
yeah, whether you include a UBO or an LLC or just work with an NLT or maybe a second NLT and layer them.
the LLC is existing, so I don't think we need to throw anything else into the mix. I think we can manage
That's
between.
one of your hats. You're called an estate engineer.
Yeah,
Mhm. That's a good title.
Yes,
Yeah, yeah. Less is more in this space, right, Bradley? Like we don't want a proliferation of stuff just for the sake of stuff.
right.
Streamline your operations. The only reason to have multiple layers is if the business that you're operating requires that level of complexity.
yes.
Well, and it depends what separation you're trying to do. So if you've got an operating entity that is your face, that is your front, that is operating as the company, just don't put assets in there. Put assets somewhere else, but use that as an operating. That's perfectly fine. It's just the same as having an LLC out front, except it's not a reporting entity. So, you could still do that, but I just think it's just important that you keep assets isolated where they're protected at all times.
Yeah. So in Amavel's case, it's a printing business, graphic design business. So any printing equipment, for example, could be moved into the trust so that the LLC is just like the operating arm, but the assets are, if it's a significant printing press, for example, those pieces of equipment might be worth a lot of money. So you would want them separated so that they're protected. So no matter what happens to the LLC, you've got separation of between your LLC and the assets, right? So that's easily done.
Sense. Victoria asks, with an NLT trust being international, is there an advantage to any particular state?
Well, the trust is not registered with any state, so it's not like you're paying state taxes or and all the benefits of the privacy protections that Wyoming, for example, provides statutory entities applies to statutory entities. So the NLT, because it's non-statutory, it's kind of irrelevant. So you can domicile it in any state you like, and you still have the same protections and privacies.
Thank you very much. Elizabeth asks, in regard to the revocation of election and jurisdiction, do they not assume we are 14th Amendment federal citizens as a federal employee in the public charitable trust? Would you suggest separating ourselves from the federal citizenship to being a state citizen?
Yes, absolutely. I'm sure Jude would agree.
Yeah, that's a tough issue because we when you follow my methodology for lecturing the IRS about its limitations based on the law, none of it applies. So the 14th Amendment hijinks of, creating citizens, yeah, there's no benefit to it. But I also don't think you have to get that much in the weeds to be free from the encumbrances of the income tax, for example. As a matter of law, if the law doesn't apply to you, then your income is not taxable. Now, if you choose to do some sort of government work, then that level, that any monies that you derive from that, that is a constitutional tax. It's being applied to your privilege of deciding to work for the government. Most of us are not in that space. We're going to avoid it like the plague because we are private people. But you can have that level of freedom without uh, attending to too much of the details. At the end of the day, all of it is dogland. They want us busy chasing our tails, trying to figure out how to enforce our rights and what forums to make our declarations in. We just don't have time for that kind of nonsense. Let's live privately out of our private trusts. If you want to engage in business, do it in a private way using the methodologies that I've discussed through the NLT Trust. And you'll find it a much more rewarding life than trying to figure out how many declarations you can submit to the government. They're really not entitled to our private information. So it's a little bit of a nuance, but yes, in principle, I agree with Tonson.
It's an interesting phenomenon that we have that goes on because all of the government employees, and this includes Congress, Senate, House, when they, by their choice, accept that job, they elect themselves to be a part of that system. They always refer to it as a voluntary tax system. I mean, go back, listen to all their rants. They talk about it being a voluntary tax system all the time. Yet they're only going to talk about one way because why? That's the one they live in. As a government employee, they have no choice. So if you go to the government and say, "What do I do?" They're going to tell you one way to do it. It's just the way it is. But now you're finding out if you're listening to this that there is options. There's always been options. I don't think the Mennonite and Amish have to have these conversations because they don't participate either.
The free man doesn't ask for permission. Sorry, Tonson.
Yeah, part of sovereignty consciousness is not asking the government for permission to be yourself. Oh, fill out a form and get approval, get some sort of certification that I'm a sovereign. No, you just are.
100%.
So another question on the ROE is from Betsy. If you have an ROE and the IRS sends you a form letter to file a tax return, who do you send your notice to saying that you have an ROE?
I'll take that one. I do a lot of tax work. Right back to that, whoever it is that sends it to you. And sometimes they come up with fake addresses. So put two others on. Send it out via certified mail. Send it to the commissioner of who is currently Besant as acting commissioner, I think. Deputy commissioner, which is probably a vacant position still because they're still playing, what do you call it, musical chairs at the IRS, as we all know. But until they keep, sending these notices, you just communicate back with them and copy the superiors above them, the commissioner, the deputy commissioner, and then the office that sent you that missive with a very strongly worded letter. Hey, I've already taken care of this. You know that this is on file. Don't communicate with me ever again as a taxpayer. I've already told you this. And whatever else you want to tell.
I just wanted to alert all the Americans on the show today that we have the revocation of election at brillianceandcommerce.com/freedom from tax as item number one there. And you can do it yourself at no cost. We don't charge anything for it. It's a gift to our fellow Americans. It's very simple. If you have Microsoft Word on your computer, you can do it. However, a lot of people like assistance, and we don't provide that assistance here at BIC. We have referred people to Kelly Alexander in Las Vegas, but she got overwhelmed. She's been working 80-hour weeks. And when I discovered Jude, I discovered that his firm does provide assistance for this. So if anyone, doesn't want to go through the process of filling it out and filing it, Jude's firm can assist you with that. And I wanted to thank you for that, Jude.
You're quite welcome, Tonson. Thank you.
And related to that, Victoria is asking, do you have to be in Washington to have an Article 3 court? I'm in California. And the answer is no, Victoria. I too was in California when I did my Article 3 case in 2021, 2022. It can be done online. I didn't have to travel.
Perfect. Very good to know. And then going back to the W-9, George is asking, can you use a W-8-BEN instead of a W-9?
I'll take that on. I'm not a believer in filling out any forms. This again goes back to the principles of sovereignty. When you are a sovereign, you don't ask for permission, you don't fill out people's forms. But you have to have established your revocation of election. You can't just sort of stop responding, whatever. You got to put your stake in the ground, and the revocation is that stake in the ground that is a delimiter. If in the past I did this stuff, it was in error because I was not fully informed of my rights at law. Now that I know, it will never happen again. So that stake in the ground has to be put in place there intentionally. But
if an organization asks the Natural Law Trust to file a W-9, then it's like you said earlier, Jude, don't be afraid of it.
Right, correct.
There's a proper way to fill it out.
Absolutely. Did that answer the question, Seth, about the 10?
For W-9 and
a
W-8-BEN?
W-8-BAN is basically a foreign entity trying to fill out that
There's
form.
no need to do that.
But just avoid the form altogether. Just don't worry about it.
Yeah, I agree. It's again, when you're filling out their forms, they have all this trick language embedded in it to trip up the unwary, and we just got to get more sophisticated than that. I'm not sure if that thwarts your opportunity to do business with these organizations, but like Tonson said, in some instances, you may decide that these aren't the type of people you want to partner with. But yeah, I'm not a strong believer in submitting forms that are generated by the IRS.
To reiterate what you said before, if you find yourself in a position where you really have no choice, you have to fill out that W-9. What you want to do is you want to get it in paper form and maybe cross out U.S. citizen, write in state citizen, or whatever you consider yourself to be, and make sure you sign without recourse. Is that correct?
Without prejudice.
Without prejudice.
Without prejudice.
What that means, Seth, is in so signing and having stricken this language out that doesn't apply to me, I still maintain the right to challenge this in the future. So it is without prejudice to my right to do so.
Right.
All right. Thank you very much. Let me see. Mata asks, while the 508 exception is valid, is there not an issue of proving the church is real and a valid church?
Who's that questioner?
Mata, and I believe this is the last question.
Mata, thank you for that question. The church is not subject to definition by the government. It's not in their wheelhouse. They can't even come up with a definition. If you look at the IRS, they have come up with guidance on what a church is for many decades now. And the list goes from 8 points to 12 points to 22 points to they don't know. I was about to curse. I'll hold back. I'll restrain myself, but they anger me that much. In any event, the point is they don't know who we are. We are spiritual in nature. We are like the air. You know that it's there, but you can't see it coming or going. You hear it and you know it's there. We are people of the spirit. And I'm not talking about denominationalism or one religion or another. I'm talking about spiritual people who are attuned to the eternal, who are awake to the fact that we we transcend definition. We tell you, IRS and government, who we are. And as it pertains to the church, 508 C1A, the only reason we use that designation, again, is to give an explanation to the bank. Yes, you can open this account because while I am a church and you might not know what I am, the IRS has a specific bucket for us, and it's called 501c3. So please, you can now open this bank account. But otherwise, we don't label ourselves based on Internal Revenue Code designations or definitions. It's all dog Latin, just like U.S. citizen, U.S. versus United States versus United States of America. It's all intended to trip us up. So we take ownership of how we define ourselves, not the IRS.
You know the story of Universal Life Church, Modesto, California?
Yeah, yeah. I mean, I don't know the full story, but
That guy
I'm
was
aware
so
of it.
funny. Kirby Hensley, he appointed ministers all over the country and around the
Yep,
world,
yep.
sending in $2 a month, all tax free. He had like millions of them, like millions of dollars coming in every month.
Right.
Appointed all these people, and you can be a minister if you pass a short test, with some simple answers about God and spirituality. And he would appoint ministers, and and he beat the IRS.
That's and that proves the point that I was just making, Tonson, because they don't know how to define it. And
Uh-huh.
it's like, there are certain parameters, like you don't want to be an original religion church where you're just sort of scripting the narrative. You want to sort of hail into what they recognize,
Yes.
a recognized form of religion, religious practice, whatever, so that you're kind of just taking advantage of the system and what it offers. Um, but otherwise, they have no way of interfering under well-established principles of autonomy from the state. The church is not uh, uh, determined. It's not given recognition by the government. We don't need that. Um, they have no jurisdiction there.
Andrea, Seth, I'll go ahead and read this one, is saying, if I work for a university, can I file an ROE, or is an ROE only for self-employment? The answer is yes and no. The answer is yes. However, your university may not recognize it. Still a good idea to file it, but they may still keep withholding, and you may not be able to get them to stop doing so. What do you say, Jude?
Well, I'll take it one step further. I agree completely with Tonson. And this system that we're talking about works when you know what your rights are. And your university is not going to know what your rights are. Here's the absurdity of the position they will take. The absurdity is that they basically act as a henchman for the IRS to do its dirty laundry. That is to
Mhm.
collect the tax from you. They
Yep.
don't get paid remuneration for that. They are not agents of the government. Well, in some cases, an institute, a university might be, and that might make it even worse. But the point of the matter is this: that the IRS can simply, at the snap of their fingers, say, "Hey, university, she filed for exemption on W-4 or whatever, filed for exempt status on the basis of some revocation of election. We don't think it's legitimate." And I'm not telling you what I think could happen. I'm telling you I have clients that have had this situation arise, where the IRS communicates with the employer and says, this may be based on faulty information. And that's all that they need to say for the university to just
Yep.
recoil and revoke your recent change in your election status. And that makes them henchmen or collaborators with the government. This draws liability to them. So the next stage in the process is, if you have the gumption, if you have the resources and the money, you ought to consider putting that employer on notice. Hey, the last I checked, this designation of my exemption status was an issue between me and the IRS. How are you involved? You have no bone to pick here, no dog in the fight. So you'd better back down, or I will consider holding you legally liable for interfering with my exemption status. Now, that creates a series of protections for you, because if you put the employer on notice and the next thing you know, the university fires you, guess what? You just became a whistleblower. They can't fire you when you are advancing what you believe to be your legal rights. And if they do, they can hold additional liability under well-established legal principles and, their codes and statutes, if you will. So there is a way to put the employer on notice and hopefully get them to back down and comply with your demands.
Very good. Very good. And maybe she could retain you to represent her.
Well, like I said, if you've got the resources, yes, I'd say that's a worthwhile fight. But
Yeah.
hey, let's give them the benefit of the doubt. Do your revocation of election, file for exemption status with your HR department, and see what happens. They may honor it.
Yeah.
All right, very good. Lots of gratitude and praise for tonight's meeting. I want to thank everybody for your wonderful questions. I want to thank you, Jude, for being here to answer them. Are there any last words from anybody before we close the meeting?
Yeah, it is great to have you part of the family, Jude. Super grateful to be. Yeah.
Bradley, I appreciate you, sir. And Tonson, what a great I've enjoyed you guys. And Seth, Will, nice to meet you guys. Like I said, I've seen you guys before on TV. That's a joke, but it's good to finally be a part of the group.
Thank you, Jude, so much. We really enjoyed it. And my gosh, the time flew. And we're getting a flood of thanks coming into the chat. So we'll have you again in the future, and let's reconvene. And Bradley gave you a little bit of a break today. You didn't have to talk as much, but
Yeah.
Just,
Bradley, you knew that as a lawyer, I'd be long-winded. So
Yeah.
it's more your fault than mine.
And everyone, don't forget September 25th, we have the Will Barney update of all the greatest things going on in the government and the world and the progress towards a golden age. So keep that.
Yes, that'll be exciting. So that's a week from tomorrow.
Yes.
Awesome. Well, thank you, everybody. Appreciate the time and being a part of your show today.
Thank you.
Absolutely. Thanks again for being here.
Thanks,
Okay, everybody.
Good night, everybody.
God bless. Namaste.
God bless and namaste.